Hey everybody, this one is about all courts are Roman cult courts. And so let's get going. There's basically three kinds of jurisdictions. There's Admiralty, which is the Roman cult. There's Equity, which is the Roman cult. And there's Common Law, which is the law of the land and a law of the people. But you don't see too much of that because the Roman cult has made sure that that's not going to be around. Anyways, this is Constitution for the United States of America, Article 1, Section 8, Clause 17, to exercise exclusive legislation in all areas whatsoever over such district, not exceeding 10 miles square, as may by cession of the particular states and the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So this is talking about D.C. and federal enclaves. And this is the D.C. Code, which was done and passed in 1901. Which is located at 31 Stat 1189. This is an act to establish a code of law for the District of Columbia. And it says in Chapter 56, Section 1617, and that's at 31 Stat 1432, it says, the legal estate to be in the sestike use. And in the 1800s, a trust was called a use, which is short for usufruct, okay, under Roman law. This is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And this is very revealing, okay? This just reveals all sorts of stuff. It says, yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven out of all their former holds, they devised a new method of conveyance, by which the lands were granted not to themselves directly, but to nominal feoffees, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the lands remains in the nominal feoffee, who was held by the courts of equity, then under the direction of the clergy, to be bound in conscience to account to his sestike use for the rents and emoluments of the state, of the estate. It is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. This says so many things. First of all, it says that a sestike trust was set up by the Roman cult. That's what it says. Think about it. That's exactly what it says. And it talks about property taxes, okay, or any kind of taxes, really. It was held by the courts of equity, then under the direction of the clergy, okay, so the courts of equity even today are under the clergy, okay? All these BAAL priests, and that's the purpose of this whole video, is to show that these people are nothing but a bunch of BAAL priests. The courts of equity, then under the direction of the clergy, to be bound in conscience to account to his sestike use for the rents and emoluments of the estate, okay? That's the taxes. And then it says, it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. In 1835, the sestike use was the foundation of modern conveyancing. Well, it's still today. That's exactly what's going on today. That's why they spell the name in all block capital letters. It's a sestike use that's set up by the Roman cult, and they want their extortion. In 1835, the sestike trust was the foundation of modern conveyancing. The sestike trust is a creation of the Roman cult. In 1835, the courts of equity were run by the Roman cult. They're still run by the Roman cult today. The Roman cult wanted to make sure that they get their rent and emoluments, which is extortion, for their owned and operated Satanic trust. When Congress passed an act, think about this. When Congress passes an act to establish a code of law for the District of Columbia, and it says the legal estate to be of the Satanic use, think about it. They're essentially saying that the Roman cult owns the United States. That's what they're saying. Why do you think Congress has those fascists on their podium? Every taxpayer is a Satanic trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. Okay, this is Henry Boland's Northwest Court case, probably Washington or Oregon or something like that. This is congressional record. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust, the constructive Satanic Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. Okay, and that's basically a summary. Okay, that's page 15641 through 15646. I don't know if anybody's looked at the congressional record, but that's like 5 pages of the congressional record. That's a whole bunch of text. It might be correctly said there's no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there's no such thing. The privileges and immunities of citizens of the United States do not necessarily include all arrests protected by the First 8 Amendments to the federal Constitution against the powers of the federal government. That's Maxwell versus Dow, U.S. Supreme Court. The only absolute and unqualified right of a U.S. citizen is to residence within the territorial boundaries of the United States. And that's U.S. versus Valentine. So the point being is that it's a Satanic trust. It has no rights. No trust has rights. No corporation has rights. So, I don't know. Do you want to be a corporation or do you want to be a living soul? Citizenship is a political status and may be defined and privilege limited by Congress. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. So let's talk a little bit about Admiralty jurisdiction. The Admiralty from the highest antiquity has exercised a very extensive criminal jurisdiction. That's U.S. versus Flores, U.S. Supreme Court. Admiralty courts have jurisdiction over contracts and torts and other special cases. Again, that's U.S. Supreme Court. In the forms and modes of proceedings in causes of equity and admiralty and maritime jurisdiction shall be according to the civil law. Why do you think that they have the rules of civil procedure? All the courts are admiralty, okay? This is all coming from the Roman cult. Brown, Volume 2, 100, lays down the rules in these terms. The general rule, however, present is that the admiralty acts only in rem, and that no person can be subject to that jurisdiction but by his consent, expressed by his entering into a stipulation, a contract. That's actually an old case, Ramsey versus Allegory, 12 Wall 611. That's like early 1800s. In Krebel's report, page 500, quoted by Brown, it's expressly said that without a stipulation, the Admiralty has no jurisdiction at all over the person. Okay, so these BAAL priests have to assault you with one of their satanic contracts. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to license. All jurisdiction facts supporting claim that supposed jurisdiction exists must appear on the record of the court. That's U.S. Supreme Court again. BAAL priests in the U.S. Supreme Court. It's well known that in civil cases in courts of equity and admiralty, juries do not intervene, and that courts of equity use the trial by jury only in extraordinary cases to inform the conscience of the court. So, if they have a jury there, they can completely ignore it, and you know, it's just a charade. Okay, that is a trial with jury, and you do not want a trial with jury. That's an admiralty case. Okay, you want a trial by jury, but you will never get one. Not today, because of these Satanist BAAL priests that are running the courts. Because all of these brain-dead sheeple out there that don't have a clue about this. There must be uniformity in maritime law. The principles of maritime laws are applicable to commercial laws, and therefore there must be uniformity in commercial laws. Okay, so again, maritime law is commercial law. Admiralty law is commercial law. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. And so, again, those are all convertible phrases, and it's all coming from the Roman cult. Admiralty law, the terms admiralty and maritime are virtually synonymous. The technical niceties of the common law are not regarded. A jury does not figure ordinarily in the trial of an admiralty suit. The verdict of a jury merely advisory and may be disregarded by the court. The rules of practice may be altered whenever found to be inconvenient or likely to embarrass the business of the court. We want to railroad this guy, and so the rules are inconvenient. Let's just throw them out. A court of admiralty acts upon equitable principles. A libel of information or accusation does not require all the technical precision of an indictment at common law. If the allegations describe the offense, it is all that is necessary if it is founded upon a statute. It is sufficient if it pursues the words of the law. So it's all tied into a statute. And remember, it says here, a court of admiralty acts upon equitable principles. Okay, so admiralty and equity, it's all tied in together. This is again back to the DC Code. This is an act to establish the Code of Law for the District of Columbia, which was approved March 3rd, 1901. A condemnation of land for public use, where it says citation to owners. Okay, the said court holding a district court of the United States. And in Chapter 28, fees to officers and others, in Section 1112, and at 31 Stat 1365, where it says marshal's fees, okay, they all collect a royalty. That for the service of any citation, summons, or capias. Okay, this is all admiralty. Okay, this is all the BAAL priests. An act, again in the DC Code, if you go to Section 1114 at 31 Stat 1265, it says, non-resident infant, the court may thereupon issue to said guardian ancillary letters of guardianship without bond and without citation, or may cite such person. Okay, cite is just short for citation, right? Cite them with a citation. It goes on in the DC Code, talks about the police court. Okay, that's what they have in all the cities. Okay, all of these Gestapo thugs that are running around populating the prisons. Okay, that's all police courts. That prosecutions in the police court shall be on information by the BAAL priest. This is 31 Stat 1189, and be it further enacted. Okay, this is at the very beginning, actually. And be it further enacted that in the interpretation and construction of said code, the following rules shall be observed, namely, Third, the person shall be held to apply to partnerships and corporations, and the reference to any officer shall include any person authorized by law to perform the duties of his office. So, again, it's all talking about corporations, sesticate trusts, fictitious entities. The Supreme Court of D.C. Yeah, that's what D.C. These BAAL priests, the United States Supreme Court, that's the D.C. Supreme Court. That's what that is. Section 117, that in addition to the jurisdiction conferred in the preceding section, plenary jurisdiction, that's military dictatorship, people, is hereby given to said court holding the said special term to hear and determine all questions. That's at 31 Stat, Chapter 1, 31 Stat 1208, Section 117. Whoever falsely and willfully represents himself to be a citizen of the United States shall be fined under this title or imprisoned not more than 3 years or both. So the key is don't identify yourself as a U.S. citizen. I would never. I'm not a U.S. citizen. I'm not. Where's your proof that I'm a U.S. citizen? The term individual means a citizen of the United States or alien lawfully admitted for permanent residence. The term federal personnel means officers, employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. Okay, so that means anybody that thinks they have a Social Security number is federal personnel. So the question is do you have a Social Security number? I know I don't. And that's the argument. You see what I'm saying? The Social Security number is a number for a sesticate trust. The term citizen in the United States is analogous to the term subject in the common law. So, I don't know. You want to be their slave? Include, or the participial form thereof, is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve. That's Montello versus Salt, U.S. Supreme Court. Montello Salt, I should say, versus Utah. And this is a Dictionary of English Language, Noel Webster, and the Black's Law Dictionary basically say the same thing. Adjustum generis, of the same kind or class or nature, the construction of laws, wills, and other instruments. The adjustum generis rule is that where general words follow an enumeration of persons or things by words of a particular and specific meaning, such general words are not to be construed in their widest extent, but are to be held as applying only to persons or things of the same general kind or class as those specifically mentioned. And it goes on, it says, example, if a law refers to automobiles, trucks, tractors, motorcycles, or other motor-powered vehicles, vehicles would not include airplanes, since the list was land-based transportation. That's Black's Law Dictionary, 4th edition. This is Black's 8th. A canon of construction, when a word or phrase follows a list of specifics, the general word or phrase will be interpreted to include only the same type as those listed. For example, the phrase horses, cattle, pigs, sheep, goats, and any other farm animal, the general language, any other farm animal, despite its seeming breadth, would probably held to include only four-legged, hoofed mammals typically found on farms, and thus would exclude chickens. A U.S. citizen is not entitled to an Article 3 court, but instead gets an Article 1 court with a plenary military dictatorship jurisdiction, and Article 1, Section 8, Clause 17, Constitution for the United States of America, as defined and reinstated in National Mutual Insurance Company, the District of Columbia, versus Tidewater Transfer Company, U.S. Supreme Court 1948, which further states that citizens of the District of Columbia are not embraced by the judicial power under Article 3 of the Constitution for the United States of America. The same statement is held in Hepburn versus Dundas. In 1804, the Supreme Court, through Chief Justice Marshall, held that a citizen of the District of Columbia is not a citizen of a state. And this is the case. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power, nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. So, again, the borders of D.C. expand as necessary for their slaves. And this is where it's codified. If any citizen or resident of the United States does not reside in and is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provision of this title to A, jurisdiction of courts, and B, service of summons. This is the Uniform Commercial Code, and Act 2 enact the Uniform Commercial Code for the District of Columbia and for other purposes, located at 77 Stat 630, Public Law 88-243, and in Uniform Commercial Code Section 9.307, location of debtor. The United States is located in the District of Columbia. So if you're a U.S. citizen, that's where you're at. Citation. A summons to appear applied particularly to process in spiritual courts. Remember, D.C. courts issue citations. The ecclesiastical courts proceeded according to the course of the civil and common law by citation, libel, etc. Okay, libel is Admiralty. Okay, it's all Admiralty. And that's Tomlin's Law Dictionary, 1835, Volume 1. This is Jacob A. New Law Dictionary. It says same thing, 1750. Citation, a summons to appear, applied particularly to process in the spiritual courts. The ecclesiastical courts proceed according to the course of civil and canon law by libel, by citation, libel, etc. This is all Admiralty. Citation is also the name of the process used in the English ecclesiastical probate and divorce courts to call the defendant or respondent before them. That's Black's Law Dictionary 2nd edition, but it's also citing Book 3 of Blackstone's commentaries and in Stephen's commentaries. This is Tomlin's Law Dictionary, again, 1835 edition. The proceedings in the ecclesiastical courts are, according to the civil and canon law, by citation and libel, answer upon oath, proof of witnesses and presumptions, and after sentence for contempt by excommunication, and if the sentence is disliked, by appeal. Okay, all appeals are taken in Admiralty, and we're going to talk about that in a minute. The jurisdiction of these courts is voluntary or contentious. The voluntary is merely concerned doing with one opposes. It goes on further down. Much oppression has been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. These people are Satanists, okay? That's exactly what they are. That's Tomlin's Law Dictionary, 1835 edition. There's a citation. This is actually a lawsuit that I filed in Texas, and they do it by citation, okay? And so this is all DC codes. Okay, and let's get in closer. See the citation up at the top, and everything's in all block capital letters. It's the Sesticate Trust, and here's a ticket that their code enforcers assaulted me with in Texas. And look at that. It says up at the top, citation. Let's get in close and look at it. Okay. Customer copy, okay? It's all Admiralty, it's commerce. And look on the back, it talks about an information up at the top. See where it says customer copy and information? And you got to wait 3 business days, okay? Because they got to make sure that contract is in place. They get to assault you with one of their contracts. So we're going to talk a little bit about informations. And informations are filed in the Court of Exchequer for forfeiture upon seizure of property, for breach of laws of revenue, impost, navigation, and trade. Informations or Admiralty, okay? And information is a written accusation of a crime made by a U.S. attorney which permits the government to prosecute the individual without the benefit of a grand jury indictment. An indictment is required in any case where a person is being charged with an infamous crime. The Supreme Court ruled in Macon versus United States that any crime for which punishment is imprisonment is an infamous crime. In short, prosecutions by information have long been a means of political suppression and intimidation, okay? These Satanists, that's exactly how they do it. These BAAL priests, okay? The use of information has a long history. For example, in the reign of King Henry VII, a very oppressive use was made of them for something more than a century so as to continually harass and shamefully enrich the crown. And that's Blackstone's commentaries. The oppressive use of this mode of prosecution by information occasions struggles to procure the declaration of its illegality. Well, they're back at it again, okay? These Satanists, they just keep coming back around because people just don't get the message. The right to be represented exists only in a military court. This is Title 10. United States Code, Section 838, the accused has the right to be represented in his defense before a general or special court-martial, okay? That's exactly what is going on, or at an investigation under Section 82 of this title. And so what they do is they assault you with one of their BAAL priests. And all BAAL priests are officers. He is, in a sense, an officer of the state with an obligation to the court. That's found at 7 Corpus Juris Secundum, Section 4. His first duty is to the court and to the public, not to the client. Therefore, his duties to the client conflict with those as an officer of the court in the administration of the justice. The former must yield to the latter, okay? That's why they sell you down the river, okay? It's a kangaroo court. They assault you with one of their BAAL priests so they can sell you into slavery. Clients are also called wards of the court. Okay, so if you accept your BAAL priest, then you're a ward of the court. A ward of the court is infants or persons of unsound mind. You're an imbecile. Anybody that has a liar is an imbecile by definition. And that's Black's Law Dictionary, 4th edition. A ward of the court's an imbecile. A ward of the court's not competent. Everything is about competence and incompetence. That's why they're representing you, because you're not competent to make decisions for yourself. Therefore, the attorney, this liar, is going to make them for you. There's no such thing as an incompetent sovereign. Do you know who you are? In propria persona. This is why they want to assault you with their BAAL priest. In one's own proper person is a rule in pleading that pleas to jurisdiction of the court must pled in propria persona, because if pled by attorney, they admit the jurisdiction. So they assault you with their liars so they can assault you with their kangaroo court. That's exactly what's going on. And he is presumed to plead after having obtained lead, which admits jurisdiction. See bar members' videos 1, 2, 3. We can't even begin to count the number of times judges, lawyers, and statesmen have said there isn't any common law anymore. It's been replaced by statutes. They would be more truthful if they said there isn't any common law. It's been replaced by martial law. Remember that one of the very first citations, the Emily versus the Caroline, where it talks about how the Admiralty has to be based on a statute. Okay, all statutes are Admiralty, and this is the Diet versus Turner, and it's taken from a book that's associated with that case called The Non-Ratification of the 14th Amendment by Judge H. Ellett of the Utah Supreme Court. So let's talk a little bit about equity. Equity in the early history of the law, the sense affixed to this word was extremely vague and uncertain. This was owing in part to the fact that the chancellors of those days were either statesmen or ecclesiastics. Well, they're still ecclesiastics. Perhaps not very scrupulous in the exercise of power. Yeah, well, they're a bunch of thieves. It was then asserted that equity was bounded by no certain limits or rules, and that it was alone controlled by conscience and natural justice. And that's Bouvier's Law Dictionary, 1856 edition, but it's a cite from Blackstone's commentaries. And so, and that is exactly, you go into one of their kangaroo courts today, and the clerk masquerading as a judge up there will tell you that he can do anything he wants, and he's right. Okay, so that's all about equity. Okay, that's these Satanists again. Equity, a court of equity is one which administers justice where there's no legal rights or legal rights, but courts of law do not afford a complete remedy, and where a complainant also has an equitable right. Equity, the system of law or body of principles originating in the English courts of chancery, superseding common and statute law, together called law in the narrow sense. When the two conflict and appealing to the equity of the court, she's appealing to the king's conscience. Black's Law Dictionary, 7th edition. In the meantime, civil law is the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. That's exactly what we have as martial law rule and have for decades. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following common law, thereby destroying the common law and leaving what's called equity in its place. And that's, again, that non-ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court, related to Diet versus Turner. Laches, that's French law, remissiveness, unreasonable delay in pursuing a right or claim, always, almost always an equitable one in which the prejudice is the party against whom relief is sought, also termed sleeping on rights. The equitable doctrine by which a court denies relief to a claimant who has unreasonably delayed in asserting the claim when that delay has prejudiced the party against whom relief is sought. The doctrine of laches is an instance the exercise of reserved power of equity to withhold relief otherwise regularly given, where in the particular case the granting of such relief would be unfair or unjust. Right. So they want to assault you with their kangaroo court. They want to be able to get away with it. Okay, that's these Satanist BAAL priests. This is the Judicial Code of 1911, okay, located at 36 Stat 1078. An act to codify, revise, amend the laws related to judiciary. And in Section 9 it says the district courts as courts of admiralty and as courts of equity. Okay? And so that's all ecclesiastical. Okay? And the same Judicial Code, Chapter 2, District Courts, Jurisdiction. The district court shall have original jurisdiction first in all suits of civil nature, common law and equity brought by the United States and arises under the constitutional laws of the United States or treaties under their authority, or between citizens of different states, or is between citizens of a state and foreign states or subjects. No district court shall have cognizance of on any suit except upon bills of exchange. Okay, so that's the only way they can pay is with the IOUs. And to recover upon any promissory note or other chosen action in favor of the assignee. Third, of all civil causes of admiralty and maritime jurisdiction. And so, again, they get to assault you with their admiralty. International law rule, okay? This is taken from a book called The Jurisdiction Over Federal Areas Within the States. Report of Interdepartmental Committee for the Study of Jurisdiction Over Federal Areas Within the States, Part 2, okay? So this is huge. I mean, there's one book is like 600 pages and the other one's like about 400. Anyways, this is Part 2, a text of the law of the legislative jurisdiction submitted to the Attorney General and transmitted to the President June 1957. This is page 158, okay? So we're going to take some stuff that goes from 158 to 165. This is the international law rule adopted for areas under federal legislative jurisdiction. Federalizes state civil law, including common law. The rule serves to federalize not only statutory, but the common law of the state. Okay, remember how I said that the District of Columbia, the borders expand, the courts ruled that on numerous occasions, actually, that the borders of the District of Columbia expand as necessary for all U.S. citizens. This is page 165, and it talks about state and federal venue. It discussed the civil laws effective in an area of exclusive federal jurisdiction are federal law, notwithstanding their derivation from state law, and a cause arising under such laws may be brought or removed to federal district court. Anyway, so the point being is that all state statutes are actually federal law, and if you read them, they all apply to U.S. citizens. Okay? This is a guy, this is taken from Wikipedia, Alberico Gentili. He's recognized as the founder of the science of international law. He's been the earliest writer on public international law and the first person to split secularism from canon law and Roman Catholics theology. Okay, so all of this is coming from the Roman cult. Okay, that's exactly where it's coming from. He lived 1587 to 1608. Actually, no. That's when he was professor of civil law. He was in office for that long. Looks like he was born in 1552. So that's quite a while ago. So this is all coming from the Roman cult. That's where it's coming from. It's exactly where it's coming from. There's 2 states in every state. There's a lawful state. There's a federal territory. There's been created a fictional federal state of XXX within a state. Actually, there's 3. But because there's the state of Texas, for example, in upper and lower case, the state of Texas in all block capital letters, and then there's Texas state. So there's at least 3. Every state has at least 3. Under the international law of warfare, all parties to a cause must appear by nom de guerre, because an alien enemy cannot maintain an action during the war in his own name. And that's Merriam-Webster Dictionary, page 1534. A mixed war is one which is made on one side by public authority and the other by mere private persons. Okay, so these people, these Satanists, are cowards, and they're engaged in a secret war on you. Okay, and they want to catch you when you're unarmed and can't defend yourself. Okay, because they don't want anybody. They don't want to get shot. Okay, and so they come out with their guns, and they want to make sure you're unarmed and can't defend yourself. And so and they're cowards. Okay, they're cowards. They operate in packs. They're Satanists. They're order followers. Watch Mark Passio's video about order followers. Great video on YouTube called his YouTube channel is What on Earth is Happening. Nom de guerre, fictitious war name. Capitis diminutio, meaning the diminition of status through the use of capitalization in Roman law, diminishing or abridgment of personality, a loss or curtailment of a man's status or aggregate of legal attributes and qualifications. Capitis diminutio maxima. And this is all in Roman law, right? Meaning a maximum loss of status through the use of capitalization. All block capital letters, the highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage. When he became a slave, is swept away with it all rights of citizenship and all family rights. And that's Black's Law Dictionary, 4th edition. And this is The Law of Persons by Joseph R. Long, published 1912. And Section 3, loss of freedom. And they even talk about capitis diminutio maxima. A Roman citizen cannot be legally be sold into slavery, but he might become a slave by condemnation for crime or by being captured by an enemy. Okay? These people are Satanists. This is warfare, okay? And we got to start treating it that way, okay? And this is the commentaries of Gaius and the Rules of Ulpian, translated with notes by J.T. Abdi, LLD, and Brian Walker in 1874. Okay, so this is a book taken from the Roman Empire. They translated it. To take an instance where a person sui juris has given himself an adoption, or a woman has passed under manus, all their property and corporal, and all that is due to them is acquired by the adopting father or co-eptionator, except those things which perish by capitis diminutio, of which are kind are a usufruct, an obligation and service on part of the freedman contracted by oath, and matters enforceable by statutes. Okay, so again, that falls under capitis diminutio, right? Usufruct, matters enforceable by statutes. And this is the Trading with the Enemy Act, Title 50, Appendix B. The President, if he shall find it compatible with the safety of the United States and the successful prosecution of the war, may, during the time of the war, the President may, through any agency that he may designate under such rules and regulations as he may prescribe by means of instructions, licenses, or otherwise, regulate, direct, compel, nullify, void, prevent, or prohibit, exercise any right, power, or privilege with respect to any property by any person subject to the jurisdiction of the United States and upon the terms directed by the President and such agency or person, and such designated agency or person may perform any and all acts incident to the accomplishment or furtherance of these purposes. So, again, they're cowards, okay? And they're engaged in a secret war. That's exactly what's going on. All persons born or naturalized in the United States and subject to the jurisdiction are citizens of the United States. So that's U.S. citizens, people. Okay, all you Satanists out there that think you're a U.S. citizen, this is what you bought for yourself. And even this is an act to terminate certain authorities with respect to national emergencies, still in effect, and to provide for orderly implementation and termination of future national emergencies, which was approved on September 14, 1976. And that can be located at 90 Stat 1255, and it even says that it's called the National Emergencies Act. But in Section 502, it says that the provisions of this act shall not apply to the following provisions of the law with powers and authorities conferred thereby and the actions taken thereunder. And the stuff that doesn't apply is Section 5B of the Act of October 6, 1917 as amended, which is the Trading with the Enemy Act, people. So these cowards can still engage in their secret war. It's all for the U.S. citizen slaves, because otherwise the exclusive jurisdiction which the United States have in forts and dockyards ceded to them is derived from the express assent of the states by whom the cessions are made, and it can be derived in no other manner, because without it the authority of the state would be supreme and exclusive therein. It is a well-established principle of law that federal regulation applies only in territorial jurisdiction of the United States. There's a canon of legislative construction that teaches Congress that unless a contrary intent appears, legislation is meant to apply only within territorial jurisdiction of the United States. Okay, so it's all for the U.S. citizen slaves. And so when you volunteered to be a U.S. citizen, this is what you bought yourself in for. If a citizen acquires the same legal status as those protected by the amendment through the operation of some statutory law of Congress, then said citizen may be brought within the venue of the amendment as a statutory juristic person. By this means, citizens' birthrights become of no effect, and their rights are reduced to the inferior character of statutory civil rights. And that's again taken from the non-ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court related to Diet versus Turner. They're cowards. They're engaged in a secret war. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. The state cannot diminish rights of the people. And state statutes are actually federal statutes. In other words, when state martial law is imposed within the state to enforce national martial law, Congress has no reason to exercise its martial law powers. Okay? If a state has conformed to the new order, there is no need for Congress to intervene. And if a white citizen has not obtained standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, i.e. the statutory character of person, then Congress has no power over that individual under this clause. And that's again Diet versus Turner, non-ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court. And it really doesn't matter what race you are. It's all voluntary. You volunteer to become one of the slaves. This is taken from the Causes and Necessities of Taking Up Arms, 1775. This is what the Satanists or the cowards have been doing this for centuries. Statutes have been passed extending the courts of Admiralty and Vice Admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of law martial. Okay? And that's exactly what's going on today. Okay? That's these Satanists and assault you. They put the government into bankruptcy. He is combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for imposing taxes on us without our consent, for depriving us in many cases of benefits of trial by jury. That's Declaration of Independence, people. And it's full of stuff that's talking about martial law. In other words, we already read this one. Statutes have been passed extending the courts. This one we already read too. So it's a kangaroo court. That's what these BAAL priests do. Okay, kangaroo court, term descriptive of a sham legal proceeding in which a person's rights are totally disregarded and in which the result is a foregone conclusion because of the bias of the court or other tribunal. That's Black's Law Dictionary, 6th edition. It's a bill of attainder. Okay, it's a legislative act, no matter what their form, that applies either to named individuals or easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. Okay, there are no judicial trials. Okay, it's all a kangaroo court. These are bail priests. Okay, whenever they're dealing with a statute, it's a clerk masquerading as a judge, and that's always, it's a contract. Okay, they assault you with one of their satanic contracts. A bill of attainder, a special legislative act prescribing punishment without a trial for a specific person or group. A bill of pains and penalties is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. An unconstitutional act is not law. It confers no rights. It imposes no duties. Affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. An unconstitutional law is void, and as no law, and an offense created by it is not a crime. It never became a law and was as much a nullity as if it had been the act or declaration of an unauthorized assemblage of individuals. They're clerks masquerading as judge. They're operating in their private capacity. All oaths must be lawful, allowed by common law or some statute. If they're administered by a persons in a private capacity or not duly authorized, they're void. Okay, Tomlin's Law Dictionary, 1835 edition. This is as old as time itself. An officer who acts in violation of the Constitution ceases to represent the government. Officers of the court have no immunity when violating a constitutional right, for they're deemed to know the law. A judge loses his absolute immunity for damages only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by immunity. Anyone wearing a military uniform is an agent of the Roman cult. Okay, the wearing, this is taken from the Concordat of 1933, Article 10, that Hitler signed with the Roman cult. And the wearing of clerical dress or religious habit on the part of layfolk is liable to the same penalty on the part of the state as the misuse of a military uniform. All United States and Canada have both adopted the Concordat of 1933. And all so-called governments are bankrupt and are owned and operated by the Roman cult. That's why they put it as Sestake Trust in the DC Code. And at common law, a sheriff would have a star only, and a judge would wear a business suit. Okay, so that's how you can tell that it's the Roman cult. At common law, there's no uniform. And these are some bail priests in the Northern District of Texas and the U.S. Court of Appeals for the Fifth Circuit. And there's one, Jorge A. Solis. Okay, here's another one, Sidney Fitzwater, the whore. And here's another one, Joe Fish, the whore. And here's Terry Means, the whore. And Sam Cummings, the whore. And John McBride, the whore. Jane Boyle, the whore. Paul Stickney, the whore. Irma Ramirez, the whore. Edith Jones, the whore. Edith Clement, the whore. Okay, Jones is actually in the Court of Appeals. Clement might be in the Court of Appeals too. And there's the chief whores. Okay, that's the Supreme Court of the District of Columbia. Okay, and they have got their bail priest uniforms on, as you can see. That's those black robes that they wear. Those are bail priest uniforms, and they do various things. See, you can see some of them have the red garbage that they put on there. Okay, they have various things they put on there. Sometimes it's blue, it's red, it's various colors, but they're all bail priests. And this is canon law talking about tribunes, or I should say, tribunals. And this is all taken from canon law. Tribunal, also called courts or tribunals, except common law jury of your peers, which is trial by jury, not trial with jury. Remember, we talked at the very beginning about how a jury just advises the conscience of the court. In other words, they can completely ignore it, and they do. Anyways, all tribunals come from canon law. They assault you with their satanic contract, and then they sell you into slavery. And this is the Roman cult, the court registry investment system. This is actually Recently, there was a news item saying that they are thinking about nationalizing the Federal Reserve Bank. That's nothing but a bunch of crap. The United States is already owned and operated by the Roman cult through the International Monetary Fund and the World Bank. It is like taking it from one pocket and putting it into another pocket. That's a bunch of crap. It is typical lies and fraud that the Roman cult Satanists like to engage in for the gullible idiots out there. And this is taken from a book about the, let's go back, about the court registry investment system, okay? And so this is a page, it's kind of fuzzy, but this is talking about, there's a case number 1-98-CV-1554, and this is actually, original date is 2002, the date that this was done in 2006, and we'll go through the dates that this is covered. Anyways, you can see all these entries. And this is the Eastern District of Texas. And there's the Fifth Circuit is the Court of Appeals is the ringleader of this. When you go through this document, you can actually I got it at what was the website? I can't remember. But anyways, I had to take snapshots of it because they wanted to get my email address so that I could download it, and I'm just not into, providing all sorts of information for these website Satanists. So anyways, there was 29 pages just like this, okay, for the Eastern District of Texas, the Southern District of Texas, and the Northern District of Texas. It was a 1-week period between July 27th through August 2nd of 2006. And here's the summaries, okay? This is for the court registry investment system, the pool summary allocation report, the liquidity pool, and then it shows the U.S. Court, District Court, and Bankruptcy Courts period, July 27, 2006 to August 2nd. Okay, so that's a 1-week period. And if you look at that ending pool balance, it's, what is it? It's $2,426,360,000. Okay, so I mean, they're talking a lot of money there, okay? I mean, these courts are a money-making business, okay? And here's just the Southern District of Texas, okay? $499,096,314.77, okay? And so that's just the Southern District of Texas. And so they have this data instructions for preparing mock financial reports. And what they do is they go and sell these as T-bills. Okay, that's what they do, is they sell these as T-bills, and so they that's what this thing is talking about here. And it's case number, and that's why people find their criminal case found on Wall Street. Okay, that's exactly why, because they sell it on Wall Street. These Roman cult, what they do, these BAAL priests, is they convert a court case into a commercial transaction. They convert an Article 3 judge into an Article 1 revenue officer, BAAL priest clerk masquerading as a judge, who's working for the crown and the Roman cult. This is when you pay the filing fees, okay? The filing fees pay for the errors and omissions insurance for the BAAL priest, thereby alleviating him of any responsibility in the matter. The filing fees make it so the BAAL priest, so-called judge, doesn't care what the outcome is. The filing fees nullifies the BAAL priest's oath of office in the matter, since all errors and omissions are covered by the insurance. So then he doesn't even care, does he? He's got insurance to cover all that stuff. And so the filing fees converts the court case into a contract dispute in Admiralty. Okay, so that's why they want to assault you with their filing fees. Makes it so the BAAL priest gets to collect a royalty in the case in support of his multi-million-dollar retirement. And if there's any doubt about that, there's Harvard Law Review articles that talk about how most judges retire millionaires. Gives the BAAL priest a special motivation to dismiss the case and to thereby encourage more violations to create more business for his so-called court down the road. What a scam! Creates business for his BAAL priest buddies in the courts of appeals. Yeah, it's a win-win situation. Oh yeah, let's dismiss this one so that they can appeal it to our BAAL priest buddies in the courts of appeals. creates the opportunity to leverage the fees by 30 times, since all courts are banks, to improve the balance sheets of their so-called court, and it generates revenue for their Roman cult handlers. Okay, it's just a real money-making business, this is. So, the steps for the Roman cult. Well, the first step they had to do, okay, is they had to disappear the true Article 13 amendments so their Roman cult bar members could infiltrate. And what they did, what caused that was the War of 1812. Okay, so this has been going on right from the beginning. Okay, these Satanist Roman cult hated what was going on from the beginning, and so they had to disappear that true Article 13 amendment. The War of 1812, one of the major battles was when they went to the Capitol and they burned the National Archives, which is where the ratification records of the true Article 13 amendment would have been kept. They wanted to make that thing disappear. The second step for the Roman cult bar members to infiltrate Congress and every other government in the country, and they certainly did that. Then they needed to convert citizenship into the opposite of what was originally established, and they went and precipitated the Civil War to do that. And then they brought about the 14th Amendment, 15th Amendment, and 16th Amendment. And so that was all orchestrated so that they could convert citizenship into the opposite of what the Founding Fathers established, and create actually a second class of citizen. That's exactly, well, there was actually two classes all right from the beginning, but it converted it into the opposite of what the Founding Fathers created. And then they need to circulate fake money to make sure that nothing's ever paid for, and that's the Federal Reserve did that, although they also did it during the Civil War with the U.S. Treasury notes. And the purpose of that is to eliminate common law, okay? And because nothing's paid for. And so there's no honest measures, and so you cannot have common law without lawful money. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. And that's Colgate versus Harvey, U.S. Supreme Court. Okay, and so what they're essentially saying is that prior to the 14th Amendment, the U.S. citizen was dependent and derivative and dependent upon a state citizen. In other words, you had to be a state citizen to be a U.S. citizen. And after the 14th Amendment, you could be a U.S. citizen without being a state citizen. And so then it basically turned citizenship upside down, and that's affirmed by United States versus Rhodes, where it says the amendment reversed and annulled the original policy of the Constitution. And then in U.S. versus Anthony, it says the term resident and citizen in the United States is distinguished as a citizen from one of the several states, in that the former is a special class of citizen created by Congress, the BAAL priests up there. And so, and then step 5 by the Roman cult was to set up Roman cult schools to make sure that government employees were properly indoctrinated. And one of those is called Georgetown University, that's run by Jesuits, and it's right in Washington, D.C. They want to make sure all those government employees get properly indoctrinated, and you always hear about these people on the news media and elsewhere that went to Georgetown University. And then the final cult, the final thing that they needed to do was the Roman cult indoctrinated government employees. With Roman cult bar members, put every government into the country deep into debt to facilitate their seizure when they go bankrupt. And again, that eliminates common law as well, and puts everything under martial law rule. And that was it was actually quite simple, but it was people need to understand what's going on, and that's exactly what these BAAL priests did. Well, the BAAL priests, the Roman cult, the BAAL priests are only part of it, and so these BAAL priests have infiltrated every government. Now every judge, they're all tribunals. It's all a Roman cult, and even up to the so-called the D.C. Supreme Court. The end justifies the means is satanic. Woe unto them that call evil good and good evil, and put darkness for light and light for darkness. and they're basically selling people into slavery. If a man be found stealing any of his brethren of the children of Israel, make merchandise of him or sell it him, then that thief shall die, and thou shalt put evil away from among you. That's Deuteronomy 24:7. And through covetousness shall they with feigned words make merchandise of you, whose judgment now of a long time lingereth not, and their damnation slumbereth not. Give me liberty or give me death is a phrase coined by Patrick Henry after he witnessed a man flogged to death for refusing to take a license. So they're all going to go to hell, actually, and I think we should help them get there. By which he went and preached to the spirits in prison. That's 1 Peter 3:19, and it shall come to pass in that day that the Lord shall punish the host of the high ones that are on high, and the kings of the earth upon the earth, and they shall be gathered together as prisoners are gathered in the pit, and they shall be shut up in prison, and after many days shall they be visited. Isaiah 24:21-22. It behooves every man who values liberty of conscience for himself to resist invasions of it in the case of others, or their case may by change of circumstances become his own. If you love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. We ask not your counsel or arms. Crouch down and lick the hands which feed you. May your chains set lightly upon you, and may our posterity forget that you are ever our countrymen. And as Samuel Adams, the father of the American Revolution, nobody could say it better than Samuel Adams. When shall it be said in any country, thou the world, my poor are happy, neither ignorance or distress is to be found among them. My jails are empty of prisoners, my streets of beggars, the aged are not in want, the tax is not oppressive, the rational world is my friend, because I am friend of its happiness. When these things can be said, then may that country boast of its constitution and government. We have absolutely nothing to boast about here. The streets are full of beggars. The prisoners are full of prisons, or the prisons are full of prisoners, and we have Satanist order followers running around populating the prisons, selling people into prison. We have a gang of Satanists that have taken over the government. Now we've recently had an election, and so there's some hope. There's definitely some hope, but we'll see. That's all I can say. But if the watchmen see the sword come and blow not the trumpet, and the people be not warned, if the sword come and take any person from among them, he is taken in his iniquity, and his blood will I require at the watchman's hands. Either you're part of the problem or you're part of the solution. You are now a watchman. Circulate this video far and wide. I hope that you're found blameless. This is my effort to make sure that I am blameless on Judgment Day, and I hope that you are found blameless as well. Other videos, I've got over 230 videos that I've uploaded. Bankster Thieves 1, 2, and 3, Churchianity series, the Do-It-Yourself series, Bankrupt Corporate So-Called Governments, Bar Members, Unidroit, Martial Law is here, Quasi-Contracts and Roman Civil Law, all courts are ecclesiastical courts. I've got all sorts of videos. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are video of private information share that show these and other court citations and are available for a donation. And then this last paragraph is for the Satanist order follower revenue officers that seem to think that I'm taking some privilege or benefit because they can put their privileges and benefits up their rectal orifice. Donations to support this work are appreciated, but I prefer gold or silver coin. And but as an extremely less desirable alternative, I can accept IOUs, Federal Reserve notes, PayPal gifts, checks, money orders, etc. Send me an email for particulars, but I'd rather have gold or silver coin. If you find this useful, then you need to pay it forward. And if you don't know what pay it forward means, then watch the movie. And send me your success stories. I would be very interested in sending them. Maybe I'll make a video about them. I'll certainly put them on my blog. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email is engineerwin@yahoo. My YouTube profile is Sovereign Living. My Facebook community page, I deleted it because of censorship. And my private group on Facebook is being deleted, okay? And I've got a YouTube video out there about how to hurt Facebook. And my attitude is that, they make money off of the networks that people set up, all their friends and stuff, and advertising based on the type of people and the interests that they have. And so the way you hurt them is you unfriend everybody, and you remove yourself from all the groups, and then you delete your profile. And I'll tell you right now, if you don't do all of that, then you can delete your profile. It will never be deleted. You will be able to go back and it will all be there again. And if you do that stuff, then it will really delete. Anyways, I've got a Yahoo group called Administrating Your Public Servants. I've got a Google private group called Administrating Your Public Servants. So I appreciate you taking the time to watch the video, and I hope you got something out of it, and spread the word. You know, we can put a stop to this, but it's not going to happen without some effort. And thanks for watching, and have a real nice day.